from Safe Harbor State Law, and I want to tell you a story about, it was March 10th, 1996, was my mom's birthday. And I was awoken at about 6 a.m. by the phone ringing. In those days, you had to run downstairs to get to the land phone, and I did that. Coming awake as I ran, I was really awake quickly because I thought, well, it's an emergency. It's 6 a.m. on Monday morning. Who's ever calling me? It's an emergency. So I answered the phone, and it was my ex-husband's sister, Barb. Joe was my ex-husband. It was his sister, Barb. So when I heard Barb's voice, I thought, oh, something happened to Joe. What happened? And she said that last night he was in a car accident, and he died, and he was 39 years old. It was a total shock. And immediately I thought of my children. So my son was 11, and he pretty much lived to go see his dad at that age. You know, he did. They both saw their dad, went back and forth. And then my daughter was 9. And so this was a devastating blow to them. And telling them was one of the hardest things I ever did in my life. Most painful, especially my son. And so these are pictures of my children at that age. They were at Turtle Lake Elementary. They were in 5th grade and 2nd grade. Benji and Monica are their names. So that's the age they were when all this came down. It was devastating for years, really, walking them through it. And just the emotional loss was tremendous, of course. As you can imagine, still some loss today. But at the time, we were in crisis mode for quite a while. But the whole thing was made so much worse because the estate plan was not in order, their dad's estate plan. And to his credit, he had one. Unlike most people, he had one. It was sort of up to date, but not really up to date. So there were problems with it, and there was litigation, and there was fighting, and it was expensive, and it went on for 7 years. It went all the way to the Minnesota Supreme Court. It was, my son said, it's my whole growing up years, you know, from 5th grade, finished about the time I graduated from high school. Of course, I tried to shield them as much as I could, but they knew they couldn't get their stuff from their dad's house for 2 years. They, you know, they knew there were some things going on that we couldn't shield them from. And so for the whole family, this made everything so much harder at an already very difficult time after tragedy. And so what was wrong with the plan? 2 main things. He didn't go to an estate planning attorney. So this attorney did a little estate planning, was his divorce lawyer, and he made a pretty big mistake, but that's easy to make. And so that was a big part of the problem. And then the other part was he was going through another divorce, and he didn't update his estate plan. And so those 2 things, not keeping it up to date and not having a really good plan in the first place, is what really led to most of the problems. And so if he would have had a complete up-to-date plan, he would have avoided, I don't know, $100,000 in attorney's fees at least, and, you know, years of strife and damaged family relationships that are still damaged, honestly. And he did have a will. And so it didn't work the way he hoped, sadly. And so I really want to help you avoid that problem. That's why I created what we call the smooth sailing system. We never know when rough seas are going to come up in life, and COVID-19 is a perfect example of that. I mean, a really sobering example for all of us right now. We don't know when the unthinkable might happen, and it's really good to prepare for it, especially when there's so much we can't control. Getting your estate plan in order, you can control, and it can really help. So I'm really glad that each of you is here today to learn more about it, because this is something that's very easy to put off, and most people do. And it's not that fun, we know, to talk about it. So I just applaud you for being here to learn more. We really want to educate you and empower you to make the best decision for you. So what we're going to do is go through this, bits of the smooth sailing estate plan system. We're not going to go through all of it, of course, and we're going to focus our framework on how your will could be failing you if you have one. Of course, if you don't have one, then your lack of one is going to fail you too, for sure. So why is this important? I mean, why? I don't know why each of you is taking the time. Obviously, it's important enough for you to be here today. This is why I think it's important, what I find is important to our clients. It's our families. So this is my wedding picture. 2.5 years ago, I married John Larson. And then this is my side of the family. And so on the young man holding the baby boy, that's my son, Ben. So people tend to ask how Benji and Monica turned out. They turned out great. They still have the loss, but he's in law school. He actually works here now, and he's going to be a lawyer. So I'm really happy about that. And then over on the right, on the other side, I guess I don't know if it's right or left. Maybe the right, I guess, is Monica, and she lives in New York City, and they're doing well. They go for a walk once a week. That's it. They leave their little permit once a week right now. They've been very good with social distancing. And then Leanna's my daughter that we adopted, and you can see my grandkids in there and my kids' spouses. This is who I think about, and yes, I do have to think about keeping my estate plan up to date. I'm making some changes right now, not to the documents, but to some of the funding that I'm doing. So I don't want to leave a mess for them. And you probably too have invested a lot. Think of all you've given for your family and all you invest in. And for not a lot more time and effort, I think you can really avoid a big problem. So that's what I think about. It's for you, but it's also even more for your loved ones. So just, you can keep that in mind, the people that come to mind when you're thinking about why you're on this webinar today, why you want to see what you can do about getting your ducks in a row. So let's look at a roadmap of where we're going to go today. The next about 30 minutes, you're going to learn 3 ways that your will may be failing you. And then we'll have time for questions. Now, like we said, you can put questions in the chat, and if I see them in time and they fit in there good, I'll answer them then. Otherwise, we mainly answer them at the end usually. And then we're going to offer free resources also, because we want to give you something so that not only can you listen to this, but you can take what you hear today and get started for no cost resources that you can use, a couple of them that will help you move forward. And then I'll end with a closing story. So what I'm excited about, if you start taking steps, you're going to be getting toward the 25% of the people in America who have an updated and complete estate plan. And so 75% of people don't, you'll be getting ahead of them. And you'll avoid a lot of expense, hassle, heartache at a really difficult time for you and your family anyway. So very glad you're here. So the first thing I want to talk about is a really common misconception is that the misconception is that wills do avoid probate, okay? The truth is they don't automatically avoid probate. Wills are designed for probate, actually. So there are cases where you can avoid probate with a will, and we have helped some clients in certain circumstances do that. It's not as certain that it can happen, but if things are simple and they stay in order, sometimes it can happen. But a lot of people think, but I have a will, therefore no probate. No, it's kind of the opposite. You have a will, so likely probate unless we can work around it. So first, let's explain what is probate. You've all heard, you can't take it with you, right? So when we die, we own some things, and then we can't keep owning them. And how does it get transferred from me to people I want it to go to after I die? This probate is the court process used to transfer assets from the deceased person, if it's me, to other people, according to either what my will says, if I have a will and it's valid, or the law. It's called intestacy law, if you heard of that. So there's the government will step in. If you don't have a will, the government will write a will for you, basically, and it may not be what you want. So that's all it is the court process. And in Minnesota, it's not as bad as other states. Say California, it's a pretty typical process, not the worst. We would say the cost is probably usually starting at about $5,000, and not to mention the hassle. So it's what you spend in estate planning is usually going to be less than the probates involved. So that's a probate. Let's see, I want to tell you more about what are the ways when a will doesn't avoid probate. So here's a picture of a little boy and a little girl. So I'm going to tell you a few stories as we go. I have lots of them. This is representing my first husband, Joe, and my little daughter, Monica. You know, she was little when he died, and he actually had other kids too than mine, and he wanted to take care of them. I know that's why he did his estate plan. That was the main thing he wanted to to do, was take care of them. He did not want them to have this hassle. He did not want them to wait 2 years to get their stuff out of the house. He wanted to make sure that they had money to help with college. And one way that it worked good, that he did have a plan, was that I repeatedly would tell my kids as they got older, and like, yeah, and we'll use some money from the trust to help pay for that, extra trip you're taking or something, because your dad, he really wanted you to do that. He would have wanted you to do that. He wanted to provide for you. And I think it was, I think that they always felt good about that part of it. The bad part about it, again, was the documents were not properly executed. So not only was there a probate, but it went 7 years of litigation. Another problem was his circumstances changed, and he had a blended family. Blended family is a big red flag that often causes problems. That's another thing. Another issue was he had minor children. Often with minor children, you can't avoid a probate. Because he didn't have a living trust, he had a testamentary trust, so he had a will, and the testamentary trust was created to protect the kids. So different sort of a trust. He basically had a will as his plan. So because of that, we had all this pain and litigation and everything, and that's not what he wanted for his really young children at the time. So that's just kind of one example and a couple reasons why. So let's look at the wills, the pros and cons of a will. Because if you're going to do an estate plan, either you're going to do a will-based plan or a living or revocable trust-based plan. And so I'm going to compare them, because this is like our most common question probably. Should I have a will or a trust? And so one of the pros about a will is that the assets go to the right people most of the time. And I'll give you some examples when it doesn't. But if all goes well, who you say in the will gets it, they're going to get it. So that's a plus most of the time. And then it's less expensive. It takes less of our time. It takes less of your time to review it. So it's less expensive now. And then the cons are probate's likely. How likely? It depends on your situation. For instance, if you have the minor kids, if someone's going to dispute it, there's going to be probate. If you have some real estate that doesn't transfer automatically or well by transfer and death deed, if you have assets over $75,000 going through, there's many reasons that will put you in probate. So what we can't tell you, of course, with everybody on this call, what's the likelihood for you. So we'll tell you towards the end of the call. One of the free resources is a really good custom consultation that we're totally willing to take the time confidentially with no obligation to kind of help you weigh that out in your situation. So some cases are better than others for avoiding probate. As I mentioned, probate costs, we would say $5,000 minimum for a pretty basic probate. That goes pretty smoothly. There's filing fees, there's publication, there's, sometimes hearings, sometimes not, just paperwork and time. And then there's time-consuming hassles. That's probably one of the biggest complaints about probate, is the time-consuming hassles. When we have parents in here and they're seniors and their kids came along to help them, it's not uncommon to have the kids say, I want you to get the trust because I want less work. But anyway, so time-consuming hassles for your loved ones, not you, at a difficult time too. It's public. So once we file the probate, we start getting solicitations, and so does your family. So that information, what's in your will, those files are open to the public. They are not private. And they're getting more public all the time because they're online. And then transfer and death deeds don't always work. I want to tell you a story about that. So sometimes if people have a simple estate, and let's say they have 2 kids, or even 1 child, this is the simplest situation. Let's say you have 1 child and you don't want to have probate, you don't want to have a trust. So you did a will and you said, I'm just going to do a transfer and death deed. So when I die, my house automatically goes to my son. And so that's what I want. And that will avoid probate if all goes well. What happens is, what if my son dies before me, okay? Or we die in a car accident together, okay? Or he dies before me and I don't update this estate plan, because most people aren't that good at keeping them up to date. what would happen is it's going to go in his estate. And probably if he doesn't have a will, it'll go to his wife. And if he does have a will, I'm guessing it's probably going to his wife, you know. And most of my clients, they want the money, if their child predeceases them, to go into trust for the grandchildren, which does have some side benefit for the spouse, but they're making sure it doesn't, like, say if my son dies and then the money goes to his wife, who I love and she's great, but then she remarries somebody else and it really ends up going to him and it doesn't really benefit my grandkids. So there's a lot of reasons why people usually want to make sure then it goes into a trust if he dies first. So that's just one of the examples. They don't always work the way you want. And once you die, I mean, it's too late to fix it. The money is going to go to whoever it goes to, and there's no amount of hassle, there's no amount of money, there's no court action that's going to make it go to somebody else. So those are the pros and cons generally of wills. And this next slide will be about trusts, pros and cons of trusts, which is another option. So the trust in this picture, there's a basket. And that's because a trust is like a basket and you put assets in it. And all the assets go in the basket are what's governed by the trust. And we work together closely with you on what the terms of the trust are exactly. So you want to get all the assets in the basket. So one of the pros is trusts are great at avoiding probate. All those reasons I gave you before for why a will might cause probate, you can fix them with a trust. So unless there's a dispute, there's not many reasons why you'd have to have a probate for the trust, unless somebody wants to fight it in court, normally. It's private, so no public information. Who gets your money, how much you have, private. It's ideal for incapacity. And we'll talk at the end today, if you lose capacity before you die, which statistics show, most of us will, maybe temporarily, maybe permanently, it works great for incapacity. Much more power and flexibility for your trustee, for your loved one, and for you. The assets will go where you want. We don't have to worry about who dies in which order. What if that happens? We can have some pretty complicated if this, then that scenarios in a trust that you could never put on a beneficiary designation or a transfer and death deed. So we can have some really nice language to take care of the what ifs, which means your document will last a long time too. We put in every contingency we think is reasonably possible so that you don't have to update your plan. Minimize taxable estate. In Minnesota right now, the taxable estate is $3 million. If you have over $3 million in your estate, it's better to have a trust, especially if you're married. And make sure to add in not only your real estate, your insurance policies, all your investments, any businesses, your retirement funds, all your assets might be more than you think. And then protection from creditors, divorce, and bad financial decisions. So if people are young, or if they're going through chemical dependency, maybe they have a special need, or maybe it's just a regular person, any money in a trust is going to be protected from creditors in bankruptcy, or if they went through divorce, if they're just not good at handling money. So all those are pros. Cons are it's going to cost more to draft. It's more complex. I bet it's simpler to administer, but it's more complex for us to draft. So it takes more time. And then it takes a little more time to move assets into the trust. So those are the pros and cons of a will versus a trust. So the main point here, number one, was it doesn't automatically avoid probate. And so I know I'm giving you a lot of information, so maybe you can just remember right now that it doesn't automatically avoid probate, and it depends on the situation. So there's more to that than what you think. You can go to the next one, Megan. This one, there's a little blurb that comes up on that picture on my paper printout. Is it gone, Megan?
There's a what?
It says here, your assets may not go where you want, number 2. It's not on the slide, but it's on the one you sent me.
Oh, this was going to be this slide is about the 50-50 brothers story, checking and savings. If you want to tell
Yeah,
that.
it's okay. All right.
Sorry, I don't know.
I just thought Okay.
Do you want me to
All
skip to
right.
that one though?
No, it's okay. It's just a little different version than what I printed out. Okay. So yes, here's the father and the son. And this is about problem number 2, why your will or your lack of a will may not work for you. Okay. And this is because your assets may not end up where you want them to end up. Now, here's a typical story. This is a father and son. So in this case, the son hired me. His dad had died. There was only 2 brothers in the family, him and his brother, two sons. And the will said, I want 50% to each son. Sounds good, right? And then I want son A to be my personal representative handling all my affairs. And I was representing son B. So this all sounds good. Doesn't it sound to you like they should each get half? Gather the money, pay the bills, divide it 50-50. Nope, that's why he hired me. Because on the checking account, my client was the beneficiary. Or he might actually have been joint. I don't remember. It's been a few years. So when the dad died, he had control of that account. He was going to get that account. And then he wasn't joint. He was a beneficiary. That's right. And so then the other account, the savings account, the brother who was in control as personal representative, he was the beneficiary of that account. So guess where he paid all the bills out of? He paid them out of my client's account. So my client got about $2,000 and the other brother got about 20. And I talked to the lawyer who drafted for the dad. And I told my client we could go to court and fight about it, but there you go. Who's going to, who knows what was in the dad's head? It goes to intent. Because if you title your will this way and you title your assets another, I think most people don't really understand what they're doing there, that they might be undermining their plan for 50-50. I don't know that the dad understood that, but how can we prove that in court? It's very hard. So I got a little bit of money for the brother, and he decided to cut his losses and, end his relationship with his brother, and we didn't sue. I think he did the right thing. But I don't believe that's what the dad wanted. So that's a good example of your assets not going where you want. And so let's look at another example I have. Here's 4 sisters. And Megan will put up a picture of this. So these 2 of these sisters, not these actual sisters, of course, came to us about 2 years ago. And 2 of them were left. Their mom had died that year. It was 2018. Their one sister died a couple months before mom, and the other one died a month after mom. It was really sad. So there was one CD with a certain large bank. And the CD said on the beneficiaries, because she had a will, okay? She didn't have a trust, she had a will plan. So the beneficiaries, she named her 4 daughters because she was trying to avoid probate. So she was making it go through the beneficiaries. And so she named her 4 daughters. Well, the one died before and the one died after. And wouldn't you think you'd still divide it in 4 shares and it would go, to the descendants, the children of the daughters who died? No, that is not what happened. That is, I'm sure, what the mom wanted, but that is not what happened. Because the contract language of the CD said that anybody who predeceases drops out. So daughter who died 2 months before, her family got nothing. Daughter who died a month later, her children got a third. So that's just a really good example of how it could even be contract language that no one's reading that is going to make your assets go somewhere other than you want when you're relying on that beneficiary designation. So let's talk a little bit about how assets transfer at death. Remember, you can't take it with you. So there's 4 main ways. The first is beneficiary designations, like we just talked about. I gave you 2 examples. So, on your life insurance for sure, and your 401k, you can have these on your bank accounts. They're called PODs, usually payable on death. You write down who you want to get your money. They have to be written really well, and you can a lot of times have a contingent. Not this person, then that person. They can get pretty complicated. Secondly, is titling of assets. This is where you own your house, say jointly with your spouse, or maybe one of your children, or people will often put an adult child joint on a checking so they can write checks. Estate planning attorneys don't recommend that. Almost never, but it's common. because they want them to be able to handle it after they die. And so both of those kind of automatically, if you die and those are set up right, the money's going to go to either who you name as beneficiary, as long as they're alive and things don't get messed up, or who's on title. They might have to file a certificate of death, et cetera. There's a little paperwork, but it's pretty automatic. The next two ways, they're not automatic. It's either by will and probate, which is usually probate, not always, and then revocable trust. So in these two, they're not so automatic. You're going to need somebody to put on a hat. For the will, it's like the personal representative hat, used to be called executor. For the revocable trust, it's the trustee hat. And so then they're going to, do some work to transfer the assets to the right people according to what the will or the trust says. And if you don't have a will, it'll be what the intestacy law says, probate. Okay, so those are the four main ways that assets transfer. So one of the things I want you to get out of this that is a surprising fact is from my stories and what I've been educating you on is that beneficiaries and joint owners both trump the will. Okay, so we said in the first place, well, there could be a transfer and death deed that would trump a will. There could be beneficiary designations that'll trump the will, and if you own something jointly, it trumps the will. So we have kind of assets that pass outside the will and then assets that go through the will. And often people are surprised that their wishes are not fulfilled because of things that are going outside and really overriding the will, like what happened to the two sons who aren't speaking to each other anymore, who did not get 50-50. So the first thing I just want you to remember is that wills often don't avoid probate. Secondly, the assets, the way your assets are set up, can trump the will, even if you have a perfectly good will, or trust for that matter. So part of our smooth sailing system that I want you to know is we always make sure we identify all your assets and identify how do we want them titled, how do we want the beneficiary designation. It's really important. It's part of your whole plan. It's not just the papers getting right, that's first step, but then we really want the assets to line up with your plan so they don't undermine what you're trying to do, because that's a big waste of time, money, and effort. So now I'm going to give you an option or a free resource. It's called a navigation plan that we are happy to send to you. If you want this, please either put in the chat, let us know, or if you can't chat, I know not everybody can do that, you can reply to our email, and Megan will send you the YouTube link. And we were happy to send this. The navigation plan, it's about 6 pages, but it's double-sided. We give it to every client for estate planning at the signing because it's a really nice summary of things that your loved ones will need to know in a crisis. It starts with like, who is the healthcare directive, who to call, who's my attorney, who's my financial advisor, where's the record, do I want to have a certain radio station on if I'm, sick? So it's a good summary of that would be helpful to your family. So we would be happy to provide that to you, and we'd recommend that be a step you could take for free to start moving in the right direction. And then you can make it available to your loved ones. Megan, I think I'm going to throw in something else. So anybody who wants this, the asset summary, we do an asset summary for all our clients to make sure these assets go in the right place. So that's really important because people, we tend to forget how exactly was that titled or who's the beneficiary or how much money is in that account. And, it can be a job just to identify all your assets, and that's important. So we'll send you that too. And you can start keeping track of what you have and how it's titled and stuff, and just try looking for your paperwork. So if you make that, especially the navigation plan, make it available to your loved ones. And also the asset summary would be good too. The ones who are really going to be handling your affairs would need to know that so they can find your assets if something happens to you and not lose track of any of them. So now we're up to number 3. It was wills don't avoid probate necessarily. How your assets are titled and beneficiary designations and such can undermine a perfect will or trust. And 3, wills do nothing for incapacity. So we've been talking so far about while you're alive. I mean, we've been talking so far about after you pass away, these questions about the will. It only covers after you pass away. You get it ready before you pass away, and then it deals with after you passed on. So incapacity, like I mentioned before, most people will be incapacitated at some time in your life, and everybody over 18 needs to have documents to prepare for that. So the will does nothing for that. In a living will, we used to call them living wills that went with healthcare directives, Minnesota. That's a totally different thing. It doesn't have anything to do with the will. So this is really about your health and your finances. So if you're concerned, look at all these people with COVID-19. I mean, they're not able to handle their affairs sometimes for 2 weeks, I think. And so you want to be able to get the care you want. You might even want to update that nowadays with what's going on with COVID-19. You might want to be thinking about, do I really want a ventilator? Like things like that. So all the more important, what kind of care you'll get, who makes those decisions, and who's going to handle your finances. Who do you really trust? And of course, some backup people. Okay, we want these documents to last a long time. So since the wills are zero help, I just want to highlight what is helpful, because everybody who's over 18 should have this what we call an incapacity plan. Oh, okay, that's fine. So the healthcare directive, you can go back to that other one, Megan, and I'm skipping it. The healthcare directive used to be a healthcare power of attorney, and the living will in Minnesota. It combined a healthcare directive years ago. So the living will and healthcare power of attorney, they're not invalid, but they're probably really outdated. So a good healthcare directive is important. And I want to highlight a change to the law. It was effective August 1st, 2016. It is still not in any free healthcare directives that I've seen anywhere. I think there's reason for that, maybe because people kind of need legal advice to fill it out, but I'm not sure if that's why they're leaving it out, but that's my guess. Anyway, this is the law. Some people in Minnesota in nursing homes were getting drugged by the staff just so they'd be easy to take care of. So they'd give them like an antidepressant and anxiety, and they'd be kind of, slumped over in the chair. And then they weren't causing anybody any trouble. They're much easier to take care of. So of course, there was a lot of outrage about that. And the legislature responded by passing a new law that says, let's say you can't make your own decisions. Your doctor's decided you're not able to decide about healthcare. So now your doctor thinks you need some kind of antidepressant or anti-anxiety drug. Maybe you never needed it before, but maybe it's a side effect of being sick or another drug you're taking. Well, your agent has no authority to say yes to that. Unless you have the right language in your healthcare directive, your agent has to go to civil commitment proceeding to get a judge to say that you can have this medication. So far, all of our clients have wanted this language, and we can customize it for you, and it makes it so that your agent does not have to go to court, and your wishes are really thought through and spelled out. And so that's super important. But besides that, you need to appoint the people you want and have your wishes in there. And as I said, we're adding some things for us because of COVID-19. So the healthcare directive is super important. And the other one is power of attorney. That's the one about money. So this is a person that can handle your finances, sign papers for you, somebody that you trust. Again, it's important to have backup people. And we also have something from a new law in August 2016. We do a digital asset authorization for you. It's good while you're alive and after you're gone. Really important that you want your power of attorney and your personal representative after you die to be able to access things digitally. Like you might pay bills by email or electronically or get statements that way. They may need to close down your Amazon account. So because after people die now, there's all kinds of fraud. Of course, they find out people who died and then they log in and steal money. So you want to be able to also close accounts and maybe put on Facebook, access Facebook and put on your celebration of life or close it down or whatever you're wishing. So really important to have that. And so we include that for all our clients. And that goes along with the power of attorney. So that's the third one. The will could be failing you by maybe causing you probate. pretty likely. Maybe if your assets aren't aligned right, it will not work well. Your money won't go where you want. And there could be expense and hassle there. And then it's not going to cover incapacity. So these are the things that a will can't do or can't always do. And I now would like to open it up for questions. Okay, Marlene said she wants the navigation plan and asset summary. We'd be happy to send that. And so, you know what I'm going to do is unmute you because I know everybody can't chat anyway.
Hi, this is Stacy Bolt. Can you hear me?
I can hear you, Stacy.
I would be interested in that packet too.
Okay. Stacy, did you hear that, Megan?
And then I did have another question. Excuse me. Can you still hear me okay? Or?
Yes, I can hear you.
Okay. My question is, my husband and I do not have any children. So my concern, I guess, would be, obviously, if something happened to me, I would want to make sure that everything came to him. But we do have niece and nephews. They are under 18, and I have heard that even though I have like them listed as my beneficiaries for, say, my 401k, my things like that, I was also told that because they're under 18, they would not get it. Is that true?
Well, they would eventually get it, but the court would appoint somebody to hold the money till they're 18, then they would get it all. So
okay,
your alternative would be to have a testamentary trust. That was like what my first husband had. So that would be created. You would set up the terms. Like, say, if any of them are still under 25 when I die, then create a trust for them, and this is who I want in charge, and these are the terms I want, and then they get the money, maybe half at 25, half at 30, or whatever you want. So you can either have, and then you can oftentimes avoid probate with that, and then with the other way, you need to go to probate. And most people don't like it because most kids can't handle much money when they're 18.
Right. Oh, totally. I just wanted to make sure. I had heard that it could get tied up, and then my understanding was it could eat all the money away anyway.
Yes,
so.
You can use the money. You can lose the money on fees, and they can be frittered away by an 18-year-old.
Okay, thank you.
You're welcome. Thanks for the question. Anybody else? I think I have everybody unmuted, and except one person I think who has herself muted. So. Which is fine.
This is Kay Lambrecht. I already have a form, the Family Protection Organizer. Is that the same as the asset summary?
No, she has an organizer. Yeah, nope, that's different. But Kay, we're doing one for you anyway. So we can still send it to you, but.
Okay.
Yeah, we do that for our clients. That's part of what we do.
But you're going to send me an.
Megan will send it too. The organizer that you have, when we do our first initial meeting with people, we have a super, super short intake form. It's like, not even a page long. So we don't want you to have to do too much work in the first place. But if we decide to work together going forward and you hire us, then we give you the longer organizer, and we're asking you to answer and think about some questions that will help you, help you answer. That's what the organizer is.
Oh, okay. So I send this Family Protection Organizer in first, and then you'll let me know.
That's the next step she's at, right, Megan?
Yeah, but I can call Kay after.
Yeah, she'll call you. She'll call you and talk to you one-on-one, Kay.
Oh, okay. Thank you.
You're welcome. Anybody else?
Yes, this is Barbara. And I was wondering if I received a navigation plan when I met with, I don't think it was Megan. Megan, I think it was, yeah.
No, you didn't. We only give that out after the signing.
Oh, I see. Oh,
we don't routinely give it out then because we try not to overwhelm people and give things in stages. So you wouldn't have got it yet.
Okay.
Do you want it?
Yes, if I could, yes.
We'd be happy to send you that, Barbara.
Okay, thank you. Guys, when we met, it was overwhelming, I must say.
I'm sorry. We're open to feedback on how to improve that. And partly why we're doing these webinars, and then the ones that turn out good, we'll maybe put them on YouTube and just try to have more resources for people, especially since it's hard to come in.
Right, exactly.
Any other questions or concerns?
I have a question.
I do have a,
Oh,
person.
you mentioned that it takes time to move assets into a trust. What sort of time frame would we be looking at?
Well, it depends on the person, but I think it was yesterday we had 3 clients call with questions, and we think that because of COVID-19 and people are home and have time, they're doing a good job of working on that. It depends, Gail, on how many assets you have.
Okay.
You know, like, are you at 4 different banks or 1? Are you, you know, because we do some things that we can do ourselves, but then you have to do stuff. If things are with a financial advisor, a lot of times we can work directly with them and they'll do the paperwork for you and you sign it. It's quite easy. So that depends on it. What takes a little longer for a trust is, I want to explain that. For a will, we're still going to give you instructions for all your assets on how they should be titled or beneficiaries named. So you'll want to be getting the beneficiary forms, filling them out, sending them in, telling us if you have any questions or concerns, but we give you really clear instructions.
Okay.
With a trust, you're going to put like your checking account and some of these assets in the trust now. And so sometimes the bank makes you get a new account number, and then you have to change your automatic payments and deposits. That's what takes longer, the automatic payments and deposits.
Sure. Okay.
So, yep. So that's another thing we can talk through in a one-on-one better and
Okay.
give you an idea about that. But we really try to go above and beyond what most law firms do in holding your hand through that process. Because if you have a great will or trust, but you don't get those assets lined up, it's not going to work.
Right. Yeah. Okay. Thank you.
Who else was asking a question?
Yeah, this is Stacy again. I just wanted to clarify. You had made a comment on the incapacity plan or the healthcare directive, and with the laws about the medications, if that is wrote in there, like handwritten, specifying that a certain person has that ability to make a decision, is that okay, or?
I would not recommend that. I can't. Yeah.
Mhm.
I mean, it might work, but I mean, the language has to be just right. And then I have had problems. You know, we normally, our healthcare directives are all typed, but I had
Sure.
a lady maybe half an hour away, you know, in memory assisted living kind of thing. And so I had to drive up and meet her, and then she wanted to change it a little bit. She did, and we signed it. And then, because I didn't want to charge her to drive back and, you know, all that. And then the facility wouldn't take it because there was handwritten changes on it.
Okay.
So, I mean, and yeah, you have to be careful how it's worded, I guess. That's so.
Okay.
You know, lawyers were cautious people, and so I can't say that I recommend it. No, it might work if it's written really well and everybody takes it.
Yeah, I was just curious because I know that there's some healthcare directives out there that are people just write in what their wishes are and then just have the notary, you know, sign it. So that's what I was just wondering is if somebody had wrote it in at the time.
It also has to be witnessed by 2 witnesses. You cannot use a notary if you have this language in there.
Okay.
I really think we don't charge that much for healthcare directives. I really think they're kind of a loss, you know, leader or whatever. They're not. I think most of our clients, I mean, once in a while somebody's like, they have one and they like it and we point this out to them and but usually it's not just that part, but other parts we walk them through and answer questions and customize. So, you know, I for the people I work with, I think they see the value. But that's not everybody, of course. It's a personal decision.
Yeah, yeah. No, I appreciate the insight. Thank you.
Sure. Anybody else? We could probably take another question if there is one. Okay, I'm going to go through and mute you guys. We should have time to do the, I'm going to tell you about our other offer. So far I offered you just to keep track. Oh, darn it. Let's see. I don't know why the mute button doesn't work that good. There we go. All right, just so we can avoid the burping problem, right? So just to recap, there's the navigation plan you can get, which is a really nice summary for your family and your loved ones about where to find things and who to call and so forth. Makes it much easier. The other thing is the asset summary, which is a good place to pull together your assets. It's a really good starting point if you're going to meet with an attorney or whatever, really important. Because what your assets are has a lot to do with what plan makes sense for you. Now, this is the third offer, and it's really the most helpful. It's a life and legacy session, what we call it. Megan does these. One of our attendees had said that she had met with Megan already. We're doing these virtually right now. We, we're watching the government recommendations, and we'll be doing them in person again, but we're getting a plexiglass shield and masks, and hopefully, we won't need those pretty soon. But anyway, your health is the most important to us. So right now we're still doing them virtually, but we'll offer them virtually and in person soon. So this meeting with Megan is completely confidential. It is free. It is not a pressure. Megan is going to take the time to find out all about your goals, your situation, your health, your finances. This is why we tell you it's confidential. We're going to ask you things your brother probably doesn't know, but it's all important. And so once we really understand your situation and your goals, then those pros and cons sheets about the will and the trust that I showed you, Megan can really customize it for you and say, well, you actually have a pretty good chance of avoiding probate, except for this or that. Or you might say, oh, you for sure probably would have a probate, or whatever. So we can kind of customize it. We want you, by the end of that meeting, to feel educated and empowered to make a good decision about what's right for you. So then if you decide to move together going forward, then, you can work with us and we'll go on with the smooth sailing system. But we appreciate you taking the time today. We'd be happy to do that meeting with you. That would be a good next step. And if you would like to do that, Megan has saved times on her calendar. It's actually busy. I read that estate planning calls are up like 40%. And people are thinking about this stuff and they have a little more time at home, some of us. So Megan set aside times in her calendar for the people from this call, because we know that while this is fresh in your mind, that is a good time to do it, before you forget things, because we know it's a little bit overwhelming. We're trying to do the best we can to fix that. Megan, do you want to say anything about signing up or when the appointments are or anything?
I'll send a link with an email following up this presentation, and then you can just schedule right on my calendar. So.
Yep, you can do that. And then some people might not be real used to that, scheduling on someone's calendar, and you can always shoot us your number and Megan will call you, or call us.
Yes.
612-615-9535, 612-615-9535. I talk fast. So we would recommend that you do that if you haven't done anything like that lately. And we can help you understand if you're up to date, find any gaps in your plan, identify them, and just really answer those questions you maybe didn't want to ask in front of the whole group, or just it takes more time to figure out. So that next action step would be scheduling the life and legacy session with Megan. So there's asking for the navigation plan, the asset summary, filling those out, and then the life and legacy session. So we're giving you a few options for you to take the next step, so you can take what you learned here today and go to the next step. And we really think that would be valuable for you, and we would be happy to invest that time in you. I have a last closing story. This is a smooth sailing story, we call it. So I have come from a family of 8. I'm the 5th, and my sister Kathy is 18 months older than me. So when we were about 14 and 15, we were camping. We had this little tent trailer. My parents, they were like the salt of the earth, and anyway, raised 8 kids and sent us all to Catholic schools, and they were just great parents. So we had this tent camper we would go camping in for our vacations. and we had this yellow canoe. And so we were out at, I'm pretty sure it was Lake Rebecca, wasn't far away. And it was just like this. It was a lake that was undeveloped. And so we got in the canoe and took off across the lake, and it was a beautiful day, and we were having a great time. And, you know, we liked to canoe. I even won a canoeing badge at COF camp. So felt pretty confident. And so we're like, let's go all the way across. So we went all the way across, and then we turned around, and then we realized, like, oh, the wind was at our back. That's why it was so easy. So not only that, not only were we now heading into the wind when we were tired, but a storm was coming up. One of those summer storms that comes up fast, and like the clouds were moving in and the wind was picking up, and there's like nobody on this lake except a dock that we had got in on. So it was pretty scary, and we were trying to keep it straight because when it turned to the side, you know, the waves really rocked it, and I was very afraid to get dumped in the lake, even though I always wear a life jacket because I can't swim. So, but it would be like a nightmare to me to get dumped in a cold lake and have to try to ride a canoe and everything. So it was scary. I could tell my, you know, my chest was tensed, all my muscles, and we were just working as hard as we could to get that thing across the lake. And then I turned around and looked at my sister. She was older, so she was in the rear. You know, she was steering. She had the position of authority. When I looked back at her, she was scared. I could tell. Okay, now I'm really scared. And what do families do when they are stressed, overwhelmed, scared, don't know what to do in the situation? It sounds a little like COVID-19. Well, we were arguing, of course. So we're arguing about what we were doing, and don't do that, or you paddle fast or whatever. Well, we made it across. And so I was greatly relieved. And from that, I learned to pay more attention to turn around a little sooner, to pay more attention to the weather and the signs and what's going on, and think I had a little more. And that's benefited me. So the reason I tell you this story is we don't know when the storms of life are coming. And it really does help to be prepared. And we really want your experience and your family's experience with the unthinkable happening to be like our first trip across the lake that was smooth sailing, and not like the one coming back that was unnecessarily stressful and difficult. Even though we made it, it was really hard. And so that is why we are here. We say that we help families protect what is most important, and that's you, your health, your finances, the money you've worked so hard for, and especially your loved ones and your legacy. So thank you very much for being here with us today. We hope you take advantage of our free resources to take the next step. We'd be happy to answer personal questions. Megan will be the first contact for that, and we will send you the recording. We'll send you any resources you asked for, and we are here for you in this time. Thank you very much for being on here today.
Thank you.